It's my pleasure to introduce our first debate, which will set the stage for the rest of the symposium. The title of the first debate is The Purpose of Marriage. Our moderator for this first session will be Professor Grant Nelson from the UCLA Law School. Grant has won major awards for his outstanding teaching. His area of expertise includes real estate and property law, and he's generously agreed to spend time with us today. So I'll turn it over to Grant.
Thank you, Anne. I'm deeply privileged and honored to take part as a moderator of the first debate. We are really privileged to have, as participants in this first debate, The Purpose of Marriage, two leading scholars, national scholars, on the family. Professor Koontz is a nationally recognized scholar on the family, and more particularly on the history of the family. She has written many books and articles on the family. She has appeared on many nationally televised talk shows and other programs concerning the family. We're deeply honored to have her here. She is a professor at Evergreen State College up in Olympia, Washington. Our second panelist, Lynn Wardle, has been a professor at Brigham Young, I think I counted in the back of my head, about 30 years, give or take a year or so. He also writes heavily on family law issues and has written books and numerous articles on family law issues, and we're deeply privileged to have him here. I remember him especially, and I'll never forget this, because he was a clerk to Judge John Sirica during the Watergate era and was at the center of all the Watergate scandal and constitutional crisis. So it's my pleasure to have both of these two fine scholars here. A little bit about the ground rules I thought I'd let you know, and they have agreed on the ground rules. Lynn is going to go first for 15 minutes, and then Stephanie Koontz is going to go second for 18 minutes, and then Lynn Wardle will have rebuttal for 3. The remaining time, I count around 25 minutes or so, will be devoted to questions from the audience. With that background, I'm happy to introduce Lynn Wardle. Thank you.
It's good to see Grant. He hasn't aged in 25 years since he was a visitor at Brigham Young University Law School, and still has a tremendous reputation in real estate and related fields. I'm going to talk about the ultimate question, what is marriage? I'm going to ask, to begin with, however, an audience survey. I like to always find out where the audience is coming from, so I asked 3 questions. The first question is, should same-sex marriage be legalized? You have 3 choices, yes, no, or no answer. How many think same-sex marriage should be legalized? Hands up. Grant and Stephanie, tell me what percentage. How many think no, it should not be legalized? 75-25? How many have no opinion? Okay. The second question is, should some equivalent domestic relationship, such as California's domestic partners or Vermont civil unions, be legalized for same-sex couples? That is the same as marriage, but just don't call it marriage. How many say yes? Hands up high. How many say no? And how many have no opinion? Grant and Stephanie?
People not voting.
Yeah, that's right. It's mostly 20-20 and then 40% not voting. Okay. And then finally, homosexual orientation is biologically determined, hardwired, set by factors that are largely beyond an individual's control. I was born this way. Yes?
Well, not control doesn't mean born this way, right?
Well, no, but it can be. If you believe you're born with this way, you'd vote yes.
You don't believe you were born that way.
Well, I don't want to argue the questions. Or we could have a whole debate on that. How many say yes? Hands up? No. Had no opinion. Grant? Stephanie?
80, 15, 5.
Okay, thank you. Well, I appreciate that. And so I want to talk today about the questions that grow out of that. This is sort of the outline of the paper that I'm going to present, whether I have time to orally present it all or not. This is the paper that I'm writing. It's still a work in process. Thank goodness the law review doesn't expect me to turn it in today. First is the meaning of marriage is very complex, and it's also very simple. And the context often influences the meaning of marriage or the perspective from which you're approaching it. And I'm not going to talk much about that because that would be like someone talking about a bad rainstorm in the presence of Noah. With Stephanie Koontz here, this is what she's studied and written extensively about. Though I don't always agree with her, I think that she's shed tremendous light, and she's definitely an expert. What is marriage in comparative laws, where I'm going to talk mostly, both international and interstate comparative law perspectives. Third, constitutionally, what was the importance of marriage from a point of view of constitutional theory and constitutional history? And it relates to three concepts: virtue, posterity, and marriage. Marriage was the link of the people that wrote the Constitution that was designed to secure the blessings of liberty to ourselves and our posterity. And marriage was the link. And finally, the illusions of change. That there are three different kinds of change, and you ought to make sure that you keep them separate when you're talking about change in marriage. I think that there has been actually very little institutional change in the structure, composition, constitution of marriage. In the last 200-300 years, very little change. There are two major exceptions. One of them is the proposal to legalize same-sex marriage, which is a profound change in the structure and concept of marriage, and the other was anti-miscegenation laws. And I'll talk about those in the course of the paper. The first question, the question, what is marriage, is both simple and complex, both obvious and obscure. For example, I looked in the Oxford English Dictionary, the OED, and I found that in the online version there are 54 pages, screen pages, of definitions and usage examples for the noun marriage. That includes 15 different simple definitions in 6 major categories, plus dozens of compound words and definitions. The first definition listed in the OED is the condition of being a husband or wife, the relation between persons married to each other, matrimony. However, in the small print immediately after that definition, this statement now appears. The term is now sometimes used with reference to long-term relationships between partners of the same sex, close quote. While the vast majority of OED definitions and usage examples denote male-female unions, matrimonial unions, as marriage historically has been known, that small lexicographer's comment illustrates the contemporary state of potential change and certainly confusion, as well as anything else does. Now, I'm going to skip over, as I said, my discussion of marriage having a different meaning in different context. It's just the obvious. In psychology, it may mean one thing that's different than in sociology, may be different than in history, or even within history, what approach you're using to history. Feminist studies would have a different approach perspective than, say, British studies or common law studies or studies of different societies, anthropology, so forth. And the meaning of marriage may vary for our individuals and families. What my family considers a marriage may be quite different than what the law considers a marriage. But I'm focusing on law because I'm a law professor. And I simply want to start with the standard dictionary reference in law that we all know, Black's Law Dictionary. According to the revised 4th edition that I was required to purchase when I started law school, the long-established standard accepted definition or meaning of marriage is, quote, Marriage, as distinguished from an agreement to marry or the act of becoming married, is the civil status, condition, or relation of one man and one woman united for life, for the discharge to each other and the community of duties legally incumbent on those whose association is founded on distinctions of sex. Black's dictionary cited and was largely based upon the definition in the classic 19th century American treatise Bishop on Marriage and Divorce, first published in 1852. And his definition in turn was based largely on Blackstone's commentaries, first published in 1765. So without going any further, we can trace back nearly 250 years a very clear legal understanding of marriage in Anglo-American law. Indeed, the dual gender association was identified by some of these commentators as the essence or core distinctive quality of the relationship. What is marriage in comparative law? We may learn much about our own family legal system, our family law system and procedures and policies, including what a relationship like marriage means or how it might be improved if we compare it with those of other countries or societies. As one comparative law professor wrote, a student confronted with only one solution to a legal problem has a tendency to assume that it's the right one. When he's confronted with two, he's encouraged to think. In the United States, we're fortunate that we can engage in comparative family law studies on two levels, not just on the international level, but also on the interstate level, because we are indeed a united country, union of different states. And as you know, family law is regulated primarily on the state level, and so there is significant diversity among the states, at least in some respects. Since the question, what is marriage, uses the term is as distinct from should be, I'm going to talk about the legal definition of marriage, first international. There are 191 independent sovereign nations recognized today by the United Nations. At least 137 of those nations have written constitutions that contain provisions addressing protection for marriage and or families. That's 72% of all of the sovereign nations in the world. As Appendix 1 in my paper shows, and I'm going to just give it to you here and I'll scroll down through it. "82 national constitutions contain specific provisions that refer explicitly to marriage, and 78 of those are substantive provisions. 4 of them are arguably structural rather than substantive. These provisions, thus over 40% of the constitutions of nations that have written constitutions, include protection specifically for marriage. And many of them assume that marriage is the union of a man and a woman, or imply that, and increasingly they're explicitly stating that. For instance, just in December, Latvia amended its constitution to constitutionalize a ban on same-sex marriage. Article 110 of the Constitution of Latvia now reads, "The state shall protect and support marriage, the new words, a union between a man and a woman," end the new words, "the family, the rights of parents, the rights of children." But Cambodia, marriage shall be based on the principle of mutual consent between one husband and one wife. Colombia, the family is formed by the free decision of a man and a woman to contract matrimony. Japan, marriage shall be based on the mutual consent of both sexes. Poland, I'll give you Ukraine. Marriage is based on the free consent of a woman and a man. And so it goes. As Appendix 2 shows, 32 nations have explicit provisions defining marriage as husband and wife, male and female, man and woman, as those kinds of terms, and the number has been growing. Thus, it's very important to recognize that the conjugal union of a man and a woman is an element that is deeply, widely recognized, even as a matter of fundamental constitutional law in the basic charters of many nations internationally. In the United States, my next appendix, Appendix 3, lists the status of same-sex marriage today. One state, as you know, has legalized same-sex marriage. That's Massachusetts. There's a constitutional amendment pending. They got 3 times as many signatures as they needed to bring it before the legislature, but now the question is whether they can get essentially 25% of the legislature to vote to put it on the ballot to let the people vote. to repeal the decision of the Supreme Court of Massachusetts. But as of today, one state has legalized same-sex marriage. 3 states, including this state, the great state in which I was born and raised, no, I wasn't born, I was raised here, brought here as about a year old. But California, Connecticut, and Vermont have legalized equivalent unions, but they don't call them marriage. As you know, civil unions are here domestic partners. By contrast, same-sex marriage is explicitly prohibited by statute or constitutional provision in 43 states. It is prohibited by constitution in 19 states, and additionally, in at least 6 states indicated there, proposed state marriage amendments that will prohibit same-sex marriage are going to be voted on this year. They're going to be on the ballots this year. And the state marriage amendments in the other 19 states have passed by an average of 70% in favor, so it's likely that they'll pass in those states as well. In addition, the constitutional amendments prohibit same-sex unions as well as same-sex marriage in 13 of those 19 states with marriage amendments. So that gives you, again, from the perspective of comparative American law. Now I want to turn to the next subject, and that is marriage and securing the blessings of liberty to ourselves and our posterity. The founders understood marriage to be the union of one man and one woman as a critical foundation for their concept of a constitutional republic. Marriage was believed to be to undergird the Constitution in at least 3 ways. First, it fostered virtue in the citizens who married, the current generation. Second, it was believed to be the best institution to generate, cultivate, and nurture posterity. And third, the marital family was believed to provide the best environment in which to nurture virtue in the next generation, thus ensuring protection for the perpetuation of the Constitution in future generations. Well, then I'm going to stop here. I'll wrap up. Thank you, Grant. Suffice it to say that the founders believed that virtue was essential. Madison, to suppose any form of government will secure liberty and happiness without virtue is a chimerical idea. Our Constitution was made for only a moral and virtuous people. It's wholly inadequate to the government of any other. That was standard Republican theory in the 18th century, that in order for a republic to survive, you had to have virtue in the people. How are you going to get virtue there? There were certain institutions that were thought to foster virtue, both in the current generation and the rising generation. And that's why Nancy Cott has written so extensively in her book Public Vows about the importance of marriage to the founding generation, because they saw it as the link to cultivate these factors that produced the substructure on which the superstructure of the Constitution rested. Well, I'm out of time, so I'll stop. When I talk about institutional change, I believe there are only 2 significant institutional changes that have occurred in the last 200 years, and both of them reflect the same idea of a political movement seeking to use a changing definition of marriage in order to promote a particular ideology. One of those movements is the movement for same-sex marriage today. And I'll talk about that later if I have an opportunity, but thank you very much for your attention.
Well, we were asked to talk about the purpose of marriage, not its current legal status, and Professor Wardle didn't get a chance to get to that, but fortunately I have read his writings on that, so I can perhaps finish your talk very briefly by suggesting that, as far as I can tell, the opponents of same-sex marriage, and in fact in Professor Wardle's writings, he argues first that the understanding of marriage has been consistent across the ages. Second, that it's a pre-political institution, the way that society organizes procreation and tries to give each child access to a mother and father, and in that sense procreation is more important than partnership in the historical definition of marriage. And finally, that gender is essential to the nature of marriage. And I want to make 3 points in response today. First of all, I have to say that it's simply not true that the meaning or understanding of marriage has been constant or even consistent across the ages. There's tremendous variation in what counts as marriage and what functions it serves, and there is at least one society in the world, the Na people of China, who have organized sexuality, reproduction, and child-rearing entirely outside of marriage. I'll come back to that one. But in case I don't have time, let me at least forecast my points. Nor is it true that marriage is a pre-political bedrock on top of which other social institutions were built. Marriage was political in its very origins. It is true that gender used to be essential to the nature of marriage, so essential that in many societies a person's gender role in the social division of labor trumped their actual biological sex, so that a woman playing a man's role in economic or political life could marry a woman playing a woman's role, and a man playing a woman's role could marry a man who did whatever tasks that society normally assigned a man. But in the last 35 years, heterosexual couples, not gays and lesbians, have rejected the idea that marital and child-rearing roles are predetermined by gender. The so-called activist judges that have been institutionalizing these changes in marriage are simply reacting, I will argue, to changes in the nature of marriage pioneered by heterosexuals. So let me go through those in as much detail as I can manage in the time period. First of all, the idea that traditional marriage is one man, one woman is dead wrong. That's why states are putting it in, to institutionalize an idea that was not carved in stone before. In fact, that had many exceptions. The most frequently recurring form of marriage in history has been polygyny, one man with many women. That was the form preferred by 3/4 of all traditional pre-industrial societies, and also, of course, by the man for whom Professor Wardle's University is named. Other societies have polyandry, one woman, many men. Woman-woman and male-male marriages were also recognized by numerous African American and Native American societies and a few groups in Western Egypt. China and the Sudan had a centuries-long tradition of ghost or spirit marriages, where a youth could be married to the deceased son or daughter of another family in order to forge closer ties. And in at least 2 Northwest Coast indigenous societies, if no suitable marriage matches were available in families that wanted to trade with each other, a marriage contract was sometimes drawn up between one individual and another one's foot or leg, or even a dog belonging to the household, and prurient political speculation to the contrary. The point of those marriages was not that people would have sex with dogs, because the point of those marriages was not about sex or procreation, but about organizing mutual exchange. Of course, it's always taken a woman and a man to conceive a child. And in early human societies, when we look back at the history of the evolution or invention of marriage, obviously sexually involved women and men often bonded together to provide the first circle of physical care that an infant received. But most anthropologists agree that human beings were originally collective, cooperative child raisers. The band as a whole, not separate nuclear families, was the main source of provisioning and protection for children. Marriage was an informal arrangement that scarcely differed from cohabitation and might last only a while, but its breakup did not threaten children because it was the band. Every child had a claim on the resources of all adults. That wasn't why humans needed marriage. Marriage was in its origins a very political institution. I have spent time in my life studying debates. For a long time, cultural conservatives and feminists debated about whether marriage was invented to protect women or to oppress women. I've come to believe that marriage had nothing to do with the individual relationship between the man and the wife. It was invented to get in-laws, to recruit allies. That is its most common recurring function through the ages. It is marriage brought together in band-level society people from different bands and far-flung social groupings to turn strangers into relatives, to ensure cooperation over time and space. That's why there are so many countries in the world whose ancient words for wife are those of, like in Anglo-Saxon England, peace weavers, people who weave ties between people. But at a very early stage in civilization, as substantial differences in wealth, property, and power developed, marriage alliances lost their function of building solidarities throughout society and began to serve the interests of separate kinship groups. That was the way that families then consolidated or expanded their wealth, recruited followers and workers, laid claim to political power, even concluded military alliances and peace treaties. Wealthy families needed recognized heirs so that distant relatives and ambitious upstarts would not claim their property or title when they died. And they needed to make sure that if their son or daughter had a sexual relationship with someone from a family to whom they did not want to be allied, that resulting child would have no claim upon the family name or property. Since that time, that is the point that marriage became a politicized as well as a political institution, with competing socioeconomic and political groups clashing over who could marry whom and what counted as a valid marriage. So the institutionalization of marriage at this point in history did begin to function to secure a child's claim on parents for care and inheritance. But what people forget is that the flip side of a strong institutionalization of marriage has always been the institutionalization of illegitimacy, a way of denying many children a claim on either their mother or their father, turning blood relatives into legal strangers. In Anglo-American law, a child born out of wedlock was a filius nullius, literally a child of no one with a claim on no one. And even up to the late 1960s, illegitimate children could not even collect debts owed to their deceased mother, claim support from her family, or sue for her wrongful death. And illegitimacy, incidentally, was not a minor problem in the past, affecting only an unlucky few. In 1850, half of all births in Vienna and Munich were out of wedlock. In late 19th century Paris, out of wedlock births were 1/3 of all births. And this resulted in thousands of children, 25,000 a year in Moscow and St. Petersburg, being abandoned to foundling hospitals where they often died. So for thousands of years, one central purpose of marriage was to protect the property rights of adults by denying millions of children access to their biological mother and father. But what about that procreative purpose of marriage? Of course, for most families and individuals through history, marriage has been closely associated with procreation. In some cultures, though not the Christian West, failure to procreate was grounds for divorce. But the public or the state interest in procreation and marriage was quite different than that family and individual interest. For centuries, marriage was a private contract between families. In Roman tradition, the difference between cohabitation and marriage was only a question of personal intent and family agreement. The Christian Church adopted this. The Catholic Church held that if a man and woman exchanged words of consent, if they didn't have a license, there weren't any licenses to get, without a priest's blessing, without a single witness, they were married if they said they would. The Protestant churches set more bounding rules in the 16th century, but it was not until 1754 that the English government required a license to marry. And once the state did get involved in regulating marriage, its interest in marriage and procreation was shaped not originally by the goal of giving each child a mother and father, but by the goal of preserving existing property rights and social inequalities. Historically, that is why most governments forbade marriage to slaves, often to servants, very often to poor people, or to people who wanted to marry across religious, racial, or class divisions. The European-American marital tradition clearly subordinated the goal of procreation to these other purposes. By the 9th century, the Catholic Church had ruled definitively that they would not give divorce on grounds of sterility. On grounds of impotence, you could annul a marriage, but not on divorce. Neither English nor American law has ever defined the validity of a marriage by the ability or even the desire to have children. Sometimes courts have allowed divorce or annulment when one party misrepresented their procreative intentions or ability to the other. But this, along with the impotence rule, suggests that the partner relationship has been more central to the construction of marriage than many opponents of same-sex marriage concede. And regulation of the partnership relationship has indeed been a primary purpose of marriage. Professor Wardle mentioned that there's 32 states that define marriage as between a man and a woman, often on the basis of free consent. The notion of free consent was a recent notion, and until very recently, all of these states and many more defined marriage as an institution in which husbands had power over wives. In fact, that is ever since the rise of ancient civilizations, that has been the most probably universal function of marriage, to enforce men's authority over women. In medieval Europe, a wife's disobedience to her husband was considered a form of treason, theoretically punishable by death. The right of a husband to physically correct or restrain his wife remained a central legal principle until well in the 19th century. Anglo-American law specifically used marriage to strip women of their property rights. A woman who was unmarried had the legal right to sue and be sued and represent herself. Once she was married, she became a covered woman, a femme couverte, and she had no legal independent identity. Not only did the law allow husbands to take over the property, the legal identity, the holdings of their wife, it compelled them to do so. As Lord Blackstone wrote, "A man cannot grant anything to his wife or make any enforceable agreement with her, for this would suppose her separate existence." Right up until the 1970s, even when this was true, of course, in the United States as well, that in 1836, the courts held that a husband, in virtue of his marriage, becomes absolute owner of the goods and chattel of his wife. And in the New York Supreme Court ruled in 1863 that recognizing the separate legal existence of husband and wife would sow the seeds of perpetual discord. Just as we hear today that recognizing changing marriage law will sow the seeds of discord and of the erosion of marriage. Right up until the 1970s, even after the law of coverture was repealed, most American states and Western European nations retained head and master laws that gave the husband the final control over community property and the right to make decisions, family decisions about, for example, where the couple would live and if the wife could take a job. It was also the courts that upheld a rigid division of labor in which the husband, but not the wife, was obligated to support the family, and the wife, but not the husband, was obligated to do housework, care for the children, and provide sexual services. This legal imposition of asymmetrical roles was what led the courts, on the basis on which the courts ruled that wives, unlike husbands, could not sue for loss of consortium, since only husbands were entitled to these personal services, and that husbands could not be charged with rape for forcing themselves upon their wife, because, of course, when a wife said, "I do," she had said, "I will," for the rest of her marital existence. Now, in the 1970s and 1980s, courts and legislators in North America and Western Europe began to overturn these traditional marriage rules, introducing such things as free consent between a man and a woman. They abolished the millennia-old institution of illegitimacy. They decreed that married partners were separate individuals with personal rights, and that the division of labor in marriage was no longer predetermined by gender, but could be negotiated by two individuals according to their needs and desires. They even ruled that a husband could be charged with spousal rape. He did not have a leasehold in his wife's body, as medieval theologians had claimed. This wave of judicial activism was far more radical and far-reaching in its challenges to traditional marriage than any changes in marriage that have since been proposed. But it was pioneered by heterosexuals, not gay and lesbian activists. It was heterosexuals who turned marriage into a voluntary love relationship based on personal choice, instead of an economic and political institution some people were forced to enter and some did not have the right to enter. It was heterosexuals who liberalized divorce laws so that if a marriage was not based on mutual consideration and love, the couple could part even if they had children. It was the demands of heterosexual couples to choose whether or not to have children that led courts to accept their right to use contraception to prevent procreation, and later to take advantage of assisted reproduction technology so they could become parents even if they were not naturally capable of having children. The courts were also bowing to the realities of heterosexual marriage when they repealed the long-standing rule that in every marriage there had to be a husband who played one role in the household and a wife who played a completely different one. For the past 3 decades, totally independently of the movement for same-sex marriage, courts and legislators have increasingly treated marriage as a gender-neutral alliance of two individuals who commit to intimate caregiving, either of each other, as in childless marriages, or of each other and any children they conceive, adopt, or bring to marriage. The rights and privileges of marriage are given to childless heterosexual couples not simply because male-female couples are categorically capable of procreation, as Professor Wardle has argued, but because the state recognizes there are other dependencies than those of infants and children. People can become dependent through illness, old age, accident. And it is in the state's interest that the people have the rights and benefits they need in order to perform that caregiving, which the state would otherwise have to pay for, as well as that they have legally enforceable ongoing obligations if they commit to caregiving and then walk away from it. So in conclusion, I would like to say that if, in defiance of every tradition I have ever studied, we want the central purpose of marriage to be one of organizing procreation and ensuring that all children grow up in a family consisting of one man and one woman, then we must deny marriage to childless couples. We must prohibit divorce to couples with children, except in the most extreme cases of abuse or incest. And we must force single mothers either to marry or to abort their children or to put them up for adoption. If that is the agenda of those who oppose same-sex marriage, then they should come right out and say it and see how far they get. If it is not, they should recognize that same-sex marriage is not a threat to the traditional purpose of marriage, but flows directly from the prior transformation of those traditional purposes and functions by heterosexuals. Trying to reverse those historical changes by forbidding same-sex marriage is a classic case of locking the barn after the horses are already out in the pasture. Thank you very much.
Well, Dr. Koontz's statement that courts have increasingly been describing and defining marriage as a gender-neutral alliance of two individuals is a really serious misstatement of the law. That simply isn't true. A handful of courts in the last 10 years have done so, and virtually in this country, all but one that have tried to do so have been overturned by the people amending their constitution. That just simply isn't an accurate statement of legal history or of the status of the law. Likewise, the statement that if a person acted the male role regardless of the gender, or acted the female role regardless of the gender, they could marry historically, is again a serious misstatement of the facts. Those were not marriages, they were not treated as marriages, they were not understood as marriages. They were understood to have a different function in society because those societies also had marriages, and marriages were different. It's like societies, in fact many civil countries still recognize concubinage, but that's not marriage. A man can be married to a wife and can have a concubine, and those societies recognize that, but it's not the same thing. So I think that part of the disagreement is really a matter of paying attention to the definitions of what we're talking about. With regard to change, again, I want to emphasize that whether you see change or not may depend upon what you're looking at. There is, in fact, change in marriages and in families, and has been, but you have to distinguish three kinds of aspects that you're looking at. One is change in the extent or degree of dysfunctional behavior or situations. A lot of writings about, marriage is changing, families is changing, are focusing on the rates of individual marital and family problems such as sexual promiscuity, non-marital cohabitation, rates of children being born out of wedlock, rates of divorce, and so forth. But it's true that those rates have risen significantly and are serious concerns that we ought to examine carefully, we ought to take seriously. But we've had those problems as long as we've had marriages. Marriage hasn't changed. What has changed is the degree to which we have those problems. So to say the institution of marriage is changing because we have twice as many divorces today as we did 30 years ago misperceives what is happening. Second, there are changes within individual family or marital life cycles. When I got married in 1973, my wife and I had no children January of 75, we're living in Washington, D.C. We have no children. Later, we have 2 children that are little children, and then they grow up and they're in elementary school, and then they're unsufferable teenagers, and then they're in college. And now both of them are married, and my wife and I are living alone again today. And that's the story of all of us. Yes, life changes, and families change, and sometimes we want to hold on to the past. You remember Uncle Rico and Napoleon Dynamite? You know, we want to remember how we were 30 years ago at our best, when we could run faster or throw a ball further than most people we knew. But Uncle Rico is kind of a pot-bellied, middle-aged guy. Life changes. Families change, but we want to hold on to the illusion, and some writers like to manipulate that to get a wow factor. Wow, things have changed. Well, that's life. That happens to everyone. Well, my last point, Grant, is that the institution of marriage has not significantly changed, and part of the reason that it hasn't changed is because of these other changes. Because of our family and marital life cycles changed so much, we recognize the need to have stability and continuity in the institution that can provide structure and support for those families. And that's why the institution of marriage has actually changed very little. And focusing on the gender definition of marriage has not changed in millennia until the Netherlands, within the last 5 years, legalized same-sex marriage, then Belgium, then Spain, then Canada, and now arguably how you'd interpret the Fourie decision, South Africa. Out of 191 nations, 32 of whom now are defining in their constitution marriage as the union of a man and a woman, because it's now an issue and wasn't in the past, it was taken for granted. We have 5 nations where we have things different. Thank you very much.
Now our plan is to open it up to questions from the audience, and directed to each of the panelists or to both. And if it's directed to one, I'm going to allow the other then to respond after the first person answers. Yes, sir.
I'll take 1 minute. When Dustin Hoffman got the Academy Award for Best Actor about 4 years ago, he said, I'm glad my parents had me. I'm glad I didn't use the birth control abortion, you know. Anyway, about the marriage, what is the true meaning of a marriage? What is the truth? And when Pilate asked Jesus, what is the truth? To me, truth is knowledge of the past, present, and future, which will never change. Which will never change. Like Earth is flat, also not truth. Earth is round, is truth. Now, man and woman, man is man, woman is woman. That is the truth. It will never change. My simple question to each one of you is, would George Washington, or First Congress, or First Supreme Court would sanction same-sex marriage? Yes or no?
No, they certainly would not.
No.
Because it's the truth. How about you?
Well, they would also not have sanctioned the laws that make women equal with their wives. As a matter of fact, excuse me, let me finish my sentence. No, they would not allow it. But I want to point out to you that they would also, when Abigail Adams wrote to John Adams suggesting that they make the laws protect women, her husband wrote, I cannot but laugh at your absurdity. So if you want to go with constitutional precedents and the intentions of our founders, we want to stay with slavery and with the coverture of women, and yes, one man, one woman.
I think that distorts the founders' position on slavery, I'll simply add, but it doesn't distort their view on marriage. I would agree that they would not have allowed that marriage, and that they understood the common law definition of marriage, including the incidence of marriage, not the construction, not the Constitution, but the incidence as she has described it.
The gentleman in the blue shirt.
Professor Wardle, I just want to quickly read a portion of the abstract you distributed for our consumption. In the first paragraph of it, you describe the importance of the issue of the treatment of gay couples in our civil marriage laws in the domestic context. And then you write as follows, quote, it is also a profound issue for international relations. is an integral part of the growing gap between Western and Islamic nations. Indeed, it is not an exaggeration to observe that the strong hostile reaction to how this question, that is whether gay and lesbian couples can get married, strong hostile reaction to how this question seems to be answered in the West is a significant part of what is driving the Islamic fundamentalist revolution. And I have a question and a comment. The question is simply that I'd like you to explain that statement, please.
I think it speaks for itself. The Islamic countries where Sharia applies, either Shiite or Sunni law, and there's differences between them, view this in such with such a strong reaction that is one of the reasons that is driving the gulf between the West and the East. They view the West as decadent, corrupt, and falling apart. It's sort of ironically, they're not Marxian, but it's almost a Marxian dialectic. That is, let's help them along. Because they're going to die anyway, we'll just help them along. One of my colleagues is now over in Qatar, in Doha, the capital of Qatar, where there's just a huge resurgence of concern about what's happening with marriage in the West, and how the importation of Western movies and of Western media and of Western magazines and Western ideas is going to lead to that. They're fearful of it, and they're fighting back. I don't defend. I think it's terrible what they're doing, but you want to understand what's driving them. You want to understand what is driving your enemies, the people that are sending terrorists into this country. Take a look at these differences.
The comment that I'll offer briefly, I think the suggestion that it is disagreement with Western views about the rights of gay and lesbian couples that is driving, quotes, the Islamic fundamentalist revolution. The cogency of that suggestion as a scholarly proposition speaks for itself. And I'm distressed that you would introduce that in this forum. I think that your statement at the beginning about the importance of vigorous and productive dialogue was a very important statement. I view that statement as outside the bounds of vigorous and responsible dialogue.
Well, I'm sorry that you do.
May I remember this is an academic symposium and not a political gathering, so I would hope that we would refrain from being too overly exuberant. Thank you.
Well, it simply is a reality of life, and you may not want to look at it. You can put we can all be ostriches and put our head in the sand and say, we don't know what's causing them to react this way. But if you try to understand it, this is indeed a very serious part, not the whole part by any means, but it's a very serious part of what's driving their concerns. That doesn't mean that we should change. I'm talking about, I was giving a comparative law perspective. And so I guess your analysis is, if we're studying a country where, for instance, women are not allowed to have custody, we shouldn't put that in our books, because that's offensive to our legal system, so our value system. So we won't talk about countries where women cannot get custody, or we won't talk about countries that have practices that we disagree with. I'm sorry.
Could I make
don't
one
think that helps.
comment?
Go ahead.
I mean, I don't particularly want to go into this too long, but if you think that passing amendments that marriage would be one man, one woman is going to contain the rage that has to do with Middle Eastern policy that's been going on for 50 years, I think that you're living in La La Land. I really do.
Yes, sir.
I'm a linguist, and I'm just interested in this. I wanted to refer my question to Dr. Koontz. You've described marriage as something that's, in many cultures, been used to describe lots of different types of relationships between different people, and even people's body parts, and even animals and stuff. What would be wrong in choosing, for instance, just to narrowly define the term marriage as the union for the purpose of procreation between a man and woman, and then create all these other legal relationships and give them a different term, which would allow that?
Well, I'm what I was called to do today was to make the point that you can make these decisions politically and on the basis of your value, but there is no historical mandate that says this is the way it always was. You can't rely on precedent for this. So I think we're going to be debating for the next series of debates how we should handle these changes. That's one option. It's not necessarily one I would agree with, but it's one option to discuss. The point is that marriage is a human social institution that takes very different forms in very different societies, and incidentally, there is a big difference, since you've got a linguist here, between talking about gender, the gender role, and the sex, the biological sex, and I totally stand by everything I said in the argument about that. But so we can discuss what we think the purpose of marriage ought to be. That's a valid debate about our morals, and we can pull in social science, but it's basically a value debate about what you think marriage ought to be. What it seems to me has to be ruled out, if you're logical about the history of marriage, is the idea that there is one form of marriage and content of marriage that has been stable through the ages, and that therefore we should use that, rely on that precedent.
Lynn, do you have any response? No. Okay. Yes, ma'am.
I have another question about Dr. Wardle's abstract. There's a typo here, and so I just want to ask you
If there's only one, I'll be grateful.
It's talking about the question of what is marriage, and same-sex marriage, is the most burning domestic policy issues in America today. And did you mean to say it is the most burning issue, period, or one of the most?
The most burning domestic policy issue. I believe that future social historians, looking back 50 years from now to describe this time, or 100 years, will say this is the issue that defined that period of time.
And so you count as domestic issues things like
The economy,
healthcare,
exactly.
crime.
Yeah. I think this is the most important and will have the most far-reaching consequences, how it's resolved. I think it is the issue that will define our time the way slavery defined Americans in the middle of the 19th century.
Stephanie, do you?
Well, I think that that if this is true, and historians look back and find that this was the defining issue of the times, they will be extraordinarily surprised and puzzled, and will have long scholarly debates about why a society would have spent so much time and energy on this issue when they had thousands of children, hundreds of thousands of children without health care, growing up in poverty, the highest rate of poverty in the industrial world for kids, even those kids in two-parent families. I think historians will have long scholarly debates about how America could have been doing this.
Yes, ma'am.
Ms. Koontz, when you mentioned that in the past 25 years courts have been interpreting marriage as gender neutral, I think there's a couple different ways of interpreting that. Can you explain what you meant by gender neutral? Because I don't think you meant...
That I did not mean sex neutral, no. Thank you. I'm glad to have the opportunity. They've been interpreting it that you cannot any longer determine by law that one of the partners, that the male, because he is male, must do this. The female, because she is female, must do this. They have adopted gender-neutral terms that say, who wants to raise the kids? The couple can negotiate that. The woman doesn't have to raise the kids. The man doesn't have to be the only one supporting the family. They can choose that if they want, but they can also choose a gender-neutral or androgynous division of labor of roles. As soon as that happened, that begins to, taken in conjunction with procreation, begins to make you understand why gays and lesbians have simply raised their hand and said, you have now changed this institution to the point where it has become relevant to our lives.
Yes, sir.
Professor Koontz, would you articulate what you see to be the shared public meanings that now, 2006, constitute the social institution of marriage in California, across the country?
Well, first of all, not all of these things are shared, or we wouldn't be having these debates. One of the...
Not shared, they're not institutionalized.
Well, and that's what sociologists talk about, the deinstitutionalization of marriage, the fact that marriage no longer has one single meaning or one single practice, nor is it the only way that people do enter into intimate caregiving situations, the only way that kids are raised. I think of it, I like Nancy Koontz, and we'll both be arguing Nancy Kootz's book. She incidentally has signed on to Historians' Brief in favor of same-sex marriages, and Nancy Koontz suggests that it's sort of equivalent to the disestablishment of the Church of England, that marriage is no longer has one common meaning and one legally binding way of organizing people's relations. That doesn't mean that marriage is dead, but it means not only that alternative forms of intimacy thrive, but that people then begin to debate what marriage should be about when it is no longer the only way that people can enter into adulthood, and have to change the way they recruit people into it and the way they manage it. And I think that we are, I argue in my last book that marriage has changed more in the last 30 years than the previous 3,000, despite the fact that it's been changing constantly. We are remaking marriage from the ground up, and this is part of the discussion, as are the discussions between men and women about the gender roles that they expect and the obligations they expect in marriage and outside of it.
I think part of that reflects confusing a molehill with a mountain in terms of changes. Certainly there are changes in the incidence of marriage, but not with respect to the composition, except in the last decade as this debate has developed really since 1993, when the Supreme Court of Massachusetts made a decision in Bear versus Lewin that opened the debate, really a debate that had been on the margins, but a debate that had been going on to some extent for hundreds or thousands of years. And that's because we've had homosexual relations probably as long, you can find them in ancient and antiquarian documents. The relationships are not new. The question of whether to institutionalize them is. That's what this debate is about, whether to change the institution of marriage in such a way that it is just a gender-neutral union of any two persons who have an intimate relationship. And I think we need to be aware of, certainly you can define marriage any way you want. As a matter of legal positivism, if I'm a legislator, I can define it as the union of any two creatures, a man and two goats, or a man and a sheep and a woman and two other men. You can define it however you want as a matter of legal positivism. But I think Abe Lincoln gave the best answer to that argument in the argument for legal positivism when some heckler was bothering him, and so he asked the heckler, how many legs does a dog have if you call a tail a leg? And the heckler said 5. And Lincoln said no, it still only has 4 legs. Calling it a leg doesn't make it so. Calling the union of two men or two women a marriage doesn't change the nature of the union. Men and women are different. And the union of two men or two women creates a different kind of union than the union of a man and a woman. Again, because men and women are different.
All right, we'll take a break. I think it's scheduled for